Sir, can we start? Kurian Joseph, sir, can we start? Very good afternoon and a warm virtual welcome to everyone. I hope I'm audible and visible to everyone. I'm John Sandosh, Managing Director of the Advocates League. It's my privilege to welcome all of you to the webinar and our gratitude to Hon'ble Mr. Joseph for accepting our invitation. Today, we have with us my Lordship, Hon'ble Mr. Justice Kurian Joseph, sir, former Judge, Supreme Court of India, to enlighten us, and Hon'ble Lordship will be delivering a lecture on the topic Emergence of ADR as Alternative. The Advocates League is an initiative which is devoted to work in the field of legal research and its publication, organizing conference, seminars on various topics of contemporary law. This organization is an outcome of collective aspiration and ideas of its members. With the evolution of society, the law and legal system has to respond accordingly. Hence, the legal institution also has to respond
Sorry for
accordingly.
interruption.
Yeah.
Sorry for interruption. Vaibhav sir, kindly mute your mic. Kindly mute your mic, sir.
Okay.
Please.
The Advocates League is an initiative which is devoted to work in the field of legal research, its publication, organizing conference, seminars on various topics of contemporary law. This organization is an outcome of collective aspiration and idea of its members. With the evolution of society, the law and legal system has to respond accordingly. Hence, the legal education also has to evolve and reform it simultaneously. The Advocates League will act as a mean and platform to capture the change and reform in legal education. The Advocates League has a team of students and alumni of various law colleges and universities of the country. We are blessed to have well-reputed professors and practicing lawyers as member of our editorial board. With a dedicated team and mission to bring meaningful reform in legal education, we commit ourselves to excellence. This initiative also aims to provide legal aid to realize basic fundamental rights and liberties and make a difference in society. We are blessed to have guidance and network of leading advocates, legal professionals, and eminent personalities in this regard. It also seeks to provide a platform for every law student to have their opinion, research, writing, and academic work recognized and accredited. The Advocates League is also providing law students the best internship opportunities under our internship program. I am having the pleasure to introduce everybody Advocate Vaibhav Mahajan, who will be moderating this webinar. Vaibhav Mahajan sir is a practicing lawyer in Delhi High Court and other tribunals with 7 years of experience and is managing attorney for Mahajan and Mahajan, a Delhi-based law firm empaneled with DLSA and other several corporate houses. He prefers and recommended ADR as the mechanism for dispute resolution to his clients and has successfully negotiated several out-of-court settlements. Before proceeding to the lecture, I will give a brief overview of how we intend to proceed the lecture. I will be inviting Vaibhav Mahajan sir to moderating this webinar. Then he will be welcoming Honorable Justice Kurian Joseph sir to deliver his lecture. If any of you who are participating in this webinar who have any questions, here we will be taking the Q&A section at the end of the session. After this, I'll be giving a vote of thanks. So this will be the broad overview of today's webinar. Now, I would request Vaibhav Mahajan sir to kindly take over the session.
Thank you, John, and thank you, Advocates League, for this initiative. I'm having the pleasure to introduce everybody today to Honorable Mr. Justice Kurian Joseph, sir, who would be delivering this lecture for all of us. Honorable Mr. Justice Kurian Joseph, sir, was born on 30th of November 1953 in Kerala. Lordship began his legal career when he graduated from the Kerala Law Academy in 1978. In his student life, he was the General Secretary of Kerala University Union. Lordship formally began his legal practice in 1979 in the High Court of Kerala. Within 10 years, he was appointed as government pleader. His Lordship was named as the Additional Advocate General in 1994 and was designated as Senior Advocate in 1996. 4 years later, Honorable Justice Joseph, sir, was elevated as a Judge High Court of Kerala and was made the President of Kerala Judicial Academy. Lordship was also the Chairman of Legal Service Authorities in Kerala and Lakshadweep and the Kerala High Court. Honorable Mr. Justice Kurian Joseph served as Acting Chief Justice of the High Court of Kerala twice and was subsequently appointed as Chief Justice High Court of Himachal Pradesh from 2010 to 2013. On 8th March 2013, Lordship was nominated to serve as a Justice in the Supreme Court of India. Honorable Mr. Justice Kurian Joseph was retired from the Apex Court on 29th of November 2018. ADR plays an important role in today's time when the number of litigations are rapidly expanding and increasing, and the load on the judicial system is increasing on a day-to-day basis. We must at the same time also appreciate that in terms of ADR, there is much more room to expand and improve our capabilities in India relative to the other countries. I invite now Honorable Justice Kurian Joseph, sir, to begin his lecture, and thereafter we'll be taking 5 questions which we'll be receiving from our audience for the benefit of everybody present today. Lordship.
Thank you, Vaibhav. And thank you, George, and thank you, the Advocates League. John, so all of you can hear me?
Yes, sir, yes.
That's fine, that's fine, yeah. I would, at the outset, appreciate the noble venture initiated by the Advocates League. It's thought out well, and it's planned well, and it's executed very well. The topic that you have taken for discussion today is certainly an important topic in the sense emergence of ADR. Emergence of ADR simply means, how did it become so popular? So that means it was already there. The Indian cultural tradition and the Indian societal background. We have been living in villages, we have been living in our gramas, gram panchayat, etc. So in villages, there used to be village head. So the village head used to be the person who used to take care of the disputes in the village. People used to approach him, and he used to be the sole arbiter or the sole judge, if you can say, if you want to use that popular word. And he will play the role of a conciliator, he will play the role of a mediator, he will play the role of an arbiter, he will play the role of a judge. So this was our tradition originally. From there, slowly we came to a constitutional framework. When even before the constitutional framework came in the law, in the several statutes introduced at the British time also, many statutes contained a provision regarding counseling or conciliation. For example, the Hindu Marriage Act, it contained a provision for a conciliation of the disputes in the family. Take the case of a Quran. There's a Shariat law. It also contains several provisions with regard to conciliation or reconciliation between the people who are in dispute. So this was in the culture of Indian society. This is what I wanted to say. It was in the culture of the society because people did not want to go to courts, and people wanted to settle as far as possible their disputes out of court. Then came a constitutional framework. After the Constitution of India was India was brought into effect. And prior to that also, the Government of India Act also, the system of judicial, judicial system of resolution of disputes was introduced by the British. And it became, it obtained that constitutional actual status after the Constitution. So there came the courts, the British actually started the courts in India for the, resolution of civil disputes in the name of civil courts, and they established chartered high courts also. We had chartered high courts of Madras, Calcutta, Bombay. We had those chartered high courts also, and thereafter came the constitution. Thereafter, under the constitution, several high courts were for every state was formed. We have, as of now, we have 25 high courts for 28 states as of now, and one union territory has an independent high court, that is Jammu and Kashmir, because it was a state earlier. So once the constitution came into effect, the fundamental basis of the constitutional approach with regard to resolution of disputes is actually, it must be based on a procedure established by law. What is that procedure established by law? Procedure established by law, as far as civil disputes are concerned, we have the Civil Procedure Code. As for the criminal, we have the Criminal Procedure Code. But as we all know, over 3.5 crores of cases are pending in the country as of now. So with the available court system of these 25 high courts and the district courts and the subordinate courts, we call it, civil judge junior division, civil judge senior division. With all that, we are not able to, we are not in a position to tackle the system of arrears of the cases. Though several statutes were introduced, for example, Rent Control Act, the period contemplated was 6 months. Family Courts Act, period contemplated was 6 months. Then came when the Consumer Disputes Act, the Consumer District Commissions, district commission, district authorities, state commission, national commission. The period contemplated or the original dispute resolution is 6 months. But in your experience, have you ever heard of a dispute being adjudicated and the final result having come within 6 months? I don't think. Even now in check dishonour cases, where also an alternate dispute resolution mechanism can be tried in some of the courts in the country. You will not even get a date for the first posting itself of within 6 months. No court is in a position to manage the flooded litigation in the country. So it is in that context, the Government of India, after wide consultations, thought of amending the Civil Procedure Code, introducing the ADR as an effective mechanism under Section 89 CPC. Even before that, we had another ADR that is called Arbitration and Conciliation Act, originally of 46, and thereafter it was amended in 1996. It was already there. And there came the Legal Service Authorities Act 1985. But as a procedural aspect, the Civil Procedure Code was amended, Section 89 was amended, introducing 4 alternate dispute resolution mechanisms. One is arbitration, the other is mediation, third is conciliation, judge-involved conciliation, fourth is the Log Adalat. These are the 4 methods for alternates. So what do you mean by alternate? Let's tackle that issue first. Alternate means normally resolution of disputes and settlement of your grievances and establishment of your rights. You go to only one place, that is the court. A court is an institution, a court is a service where you have an answer for your problems, your grievances, your disputes in a constitutional manner, in accordance with law. That's why we call it court of law. This is in accordance with law. But since the courts were not in a position, or courts are not in a position to manage the huge pendency of cases No, the system was envisaged as to whether the people can otherwise get the grievances redressed outside court and sometimes with the involvement of the court. So we will take it in two ways. One, the settlement of disputes through the involvement of court, settlement of disputes outside the court. So let's take the involvement of court as the first one. Section 89 says, the court should form an opinion in respect of a pending case as to whether that case is fit enough for trying with an alternate mode of dispute resolution, namely arbitration, mediation, conciliation, and log adalat. So it is the first duty that is cast is on the court. It is for the court to form an opinion that this is an eminently fit case for referring to one of the modes of alternates. So it is an alternate. Now in the present COVID system, I would say it's an additional mode of resolution. It's not only alternate, it's an additional mode of dispute resolution also. I'll come to that portion a little later. So in the alternate dispute resolution, once the court forms an opinion, then it is the duty of the court to refer to one of the modes of alternate dispute resolution. So that is, let's take first the arbitration. Arbitration, you can have a single arbitrator or a panel of 3 arbitrators nominate, each party nominates one, and those 2 arbitrators nominate a presiding arbitrator. That is under the Arbitration and Conciliation Act 1996. So the Arbitration Act is solved. There's a statute governing arbitration. For that, there should be pre-existing agreement between the parties for referring their dispute to arbitration. So as the very expression of the very word signifies, the arbitral tribunal also will adjudicate, though not following the strict procedure as is envisaged under the CPC or the Evidence Act, but they will still adjudicate your disputes and give an award. That award, if you are not satisfied, you can challenge it under Section 34 of the Act, and thereafter the further challenge also can be made. So an award passed by the arbitral tribunal, be it a single member tribunal or a 3-member tribunal, it is a decree for all purposes and it can be executed also subject to its finality. But it was found to be a little time consuming and a little expensive process because the arbitral tribunal will have to be paid their fees. That is the issue, number one. Number two, if there are several institutions which offer this arbitration mechanism, for example, if you are from Delhi, you have a beautiful center functioning in Delhi, Delhi International Arbitration Center. Their center has its own fee schedule also. It's almost similar to the Schedule 4 of the Arbitration and Conciliation. It's a cap of the maximum fee payable to arbitral members of the arbitral tribunal. So that is the situation if you have a pre-existing agreement, or if you are agreeable, even at the time of your appearance before court also, both parties can say that no, we are agreeable to have our dispute referred to an arbitration under the Arbitration and Conciliation Act. Then it is for the court to refer it, because it is the cardinal principle. It is the party autonomy. It is the parties who decide as to whether they should have their matters adjudicated before the tribunal or not. So in which case, if they make a joint request for reference to arbitration, it will not be referred to the arbitration. The second method is, I'll come to mediation as the last one. The second method is conciliation. Conciliation is only very seldom used in court. According to me, that's a very effective mechanism, because when you are sitting in the court, you are a judge. You are you are having the jurisdiction with you to decide the matter and to conduct the trial also. So conduct the trial and decide decision-making process. You can always have a little bit of what you call your jurisdiction exercise in convincing the parties that it's a case fit for settlement. You can guide them also. You can guide the parties for a settlement. That's what is called a judge-involved conciliation, judicial conciliation. That is very seldom used, because the reason is, once the judge makes an attempt for a conciliation between the parties, and after some stage the parties disagree, or parties do not agree to have the matter decided in conciliation or settled in conciliation, not decided, settled in conciliation, then it will be difficult for that particular judge who has involved himself in the conciliation process to continue with the hearing of the case, because a lot of information would have been personally shared to the conciliator. Therefore, that could be the reason why it is not very popular. But from my experience, I have been passionately using this conciliation in the High Court and in both in the Supreme Court also. Even after the parties report that the mediation has failed, I used to call the parties and ask them what exactly is your problem, where is your difference, where have you not been able to meet. And once it is told in open court in the presence of both parties and both the counsel, as a court, you have some leeway. You can always ask, why don't you give a little more give and take? Once it comes from the court, the parties take it right. I've seen people jumping in court and saying, yes, sir, we agree. Both sides agree. I've settled several such cases, both in High Court and Supreme Court. If a judge has a passion for such involvement to settle disputes, you can work wonders in court. That's from my personal experience. Let me come to the third one, Lok Adalat. Lok Adalat is a system that is introduced by the Legal Services Authorities Act, where under, you can have the assistance of prominent men in the society and also the retired judges or retired judicial officers. They will sit together, call the parties, negotiate with them, negotiate with the parties, and have, it's not a mediation. It's a deeper involvement than mediation. Discussing with the parties on the merits also, sometimes persuading the parties also, and making them realize their legal position also, and asking the parties that it is in their better interest to have the matter settled, etc. And the parties arriving at agreement to settle, and in the presence of their lawyers and the parties, an award is passed. That award has the force of decree. That is, there's no appeal against that award. It can be challenged only on a very, very, very limited grounds under Article 226 of the Constitution of India before a court, because it's a matter that is settled by the parties in the presence of a log adalat before the presiding members of the log adalat also in the presence of their lawyers also. Therefore, there's hardly any chance except that there was a what we call deliberate misrepresentation of facts or suppression of facts, etc., or a fraud played, etc., or a coercion, or a very, very limited ground this used to be attacked. So attains penalty. Now comes the fourth one, which I thought I should, which actually it is the second one, but I thought I would speak with it towards the last. That's mediation. But so what is mediation? Mediation is, there for mediation also the parties should agree. Without the agreement of the parties, no court can send a matter for mediation, because it should voluntarily come from the parties that they are willing to have the matter settled in mediation. But the court can always ask the parties, that's in the process of forming an opinion under Section 89, taking the spirit of the provision, the court can always just tell the people that this is your dispute. Why don't you try a settlement rather than waiting in the court for a decision, either by a decision after a prolonged trial, and thereafter one party winning, one party losing, the losing party again taking the matter in appeal, and the appeal again pending for 5-10 years, again the second appeal goes like that. Instead of that, why don't you purchase peace? This used to be the word I used to ask in court. Why don't you purchase peace by a little bit of give and take here and there, instead of wasting your time and energy and money in court? And 99% of the cases which I have come prepared, that is an element of settlement in the matter, and which I have put to the parties in the open court, they have all very well cooperated. And the cases I have referred for mediation, again 90% have been settled also, and on the basis of, and before the mediator, what does the mediator do? Mediator is a neutral person, totally unbiased. He does not ask the parties to form an opinion, not form it. He, first of all, brings the parties together and asks them to restore their communication and help them to identify what exactly is the root cause of their problem. I used to say that there should be a grievance first. A grievance becomes a dispute. Dispute becomes a litigation. So from the litigation, the mediator will help you to identify the dispute. From the process of from the stage of dispute, the mediator will help you to identify what exactly the grievance. That grievance is actually it's called interest or underlying interest. At some stage you will reach an underlying interest where the parties have been fighting about. Once that interest, underlying interest is sorted out with the assistance of the cooperation of the parties and the mediator helping them to communicate and bring out the actual issue. The underlying interest is called what is actual interest, the quintessence, the actual issue, the actual problem, the real issue, the real problem, etc. You can call it in different words, different expressions also. Once that is identified, then the next is how to find a solution for this problem. So what are the alternatives? Do you want a decree from a court, or do you want the matter to be finally settled? If it is a question of money, if it is a question of a dispute on a property, if it is a question of what they call a dispute on some movable assets, whatever it is, maybe movable property, movable assets, your civil rights, your money, your claim for compensation, all these things are within the purview of a settlement, because a little bit of a give and take here and there, you can have the matter settled with the parties. If you are a inter-party dispute, because it is a dispute actually between two parties. So the mediator helps the parties to evolve suggestions. So he is called a facilitator. He facilitates the process of a communication between the parties. He facilitates the process of identifying the problem existing within, that is the root cause of the problems within the parties. He facilitates the parties to evolve some sort of a solutions, is called alternatives for the solution of the problem. And then if the alternatives suggested by the parties are not acceptable at both sides, then he will again facilitate the parties to find out options. Is there any other option? Once you decide that this is the, once you identify the problem and decide to settle the problem, and if the alternatives suggested by both of you are not feasible, then the mediator will again ask you or help you or facilitate you to find out other options for the resolution of the disputes. It's called options. And one of the options, if both parties agree, then that means you have reached as a settlement. Then the mediator will have to see whether the settlement arrived at is actually legitimate, whether it is legally permissible, settlement. That's called legitimacy. Once it is found legitimate, then the mediator will have to get a commitment between the parties, commitment from both the parties, to have compliance of the settlement. And on those terms, you draw up an agreement. It's called a mediation settlement, and that settlement is reported to the court, and the court passes a decree in terms of the mediation settlement or mediated settlement. So that decree becomes a final decree, because both parties cannot go beyond that and behind that. Whatever you have put in that settlement, it becomes the decree for all purposes, and there is no case further. Then because both parties have won. It's called a win-win solution. That is the effect of mediation. There is nobody winning, nobody losing. Both parties have won. So both parties are happy. The peace is restored in the family, peace is restored in the society, and there is no more litigations. All litigations, civil, criminal, have been settled also, and that is the effect of a mediation. Now, one more question can arise as to whether there is a mediation possible or permissible in criminal cases. Yes, in certain criminal cases, mediation is certainly permissible. Where, for example, cases which are compoundable under the CRPC, cases pertaining to the negotiable instruments 138, we call it, 138 Dishonor of Checks, Negotiable Instruments Act, check dishonor case, popularly known as check dishonor cases, cases pertaining to domestic violence, cases pertaining to the maintenance under section 125 CRPC. These are some of the areas where you can still have your cases settled in mediation. And there is one more area where you can ask the court to assist you to set, because once, suppose there is a matrimonial dispute in the family where there is a case under for section 498A also. As you all know, 498A, there is no compounding. So once the parties have otherwise settled their disputes and they have decided to purchase peace between them, either to live together by an approach of forget and forgive, rather forgive and forget, or rather they have decided to part as friends to settle all their disputes in time by an amicable solution, by either payment of money or whatever it is. So once the parties have purchased peace, Supreme Court has held that it is a duty of the court to permit the parties to live peaceably further, rather than again driving them to the process of a trial in a criminal case. Therefore, in exercise of the inherent jurisdiction vested in the court under section 482 CRPC, the High Court and the Supreme Court it's a power of the High Court, but in matters that power is co-exercised, it can be exercised by the Supreme Court also, because it is an appellate jurisdiction also. So in exercise of that power, the Supreme Court and the High Court and the Supreme Court can quash those cases once it is convinced that all other disputes have been settled, and it will be in the interest of the parties, in the interest of justice, and for securing the ends of justice, to have the criminal cases also quashed. In that case, only the High Court and Supreme Court can exercise the power, not the other court also. So this is where the what they call the mediation in criminal cases come into picture. And mind you, see, all these alternate dispute resolution mechanisms are permissible, as you all know, only when there is a dispute to be tackled. In other words, if there is a serious question of law to be decided on the interpretation of a statute, on the interpretation of a provision of the Constitution, it is not possible to have a mediation, because the result will depend on the outcome of the interpretation. But there are cases where parties would come and say, those are all academic for us. As far as I am concerned, I need only my money. I'm not bothered as to what is the problem. As far as I am concerned, I need only my work to continue. I'm not bothered as to the question of law. So there are such situations also where the parties voluntarily report to the court that, we don't want the question of law, but we are prepared to have the matter settled like this. Then this ADR is possible. Whereas in a case where the outcome will depend on the interpretation of a provision in a statute or a constitutional provision, it is not possible to have the ADR. This, in short, is actually the story of emergence of ADR in India. Why it has not taken off? Let me take that part also, touch that part also, and leave the matter for a little bit of discussion. It has not taken off quite well on account of three aspects. One, of course, the courts have not been passionate. As I told you, unless, because people have a lot of faith in court. So therefore, if the court, or rather we call, let me say the judge, or the civil judge, or the judge, presiding judge, the judge or something comes from the court, it will go a long way to for the parties to have an introspection as to why should we waste our time, money, and energy in court? Why don't we settle it? So that's the advantage. The moment the court makes an observation, court makes a request to the parties to go for a settlement, then it's easy for us. So the commitment of the institution as court and the passionate approach of the court to have the matter decided or not decided, settled in mediation or arbitration or conciliation or log adalat is very, very important, because the court will have to guide the parties. Court will have to not pressurize but persuade the parties. I would like to use the word guide the parties, that it is in their interest to have the matter settled. At all, this is the dispute. At all, the dispute only is only this. You identify the dispute and ask the parties to take a view one way or other, a bit of give and take here and there, and somebody will help you, a mediator will help you, law adalat will help you, conciliator will help you. Why don't you just do that? It will help the parties. So the passionate approach to the court is very important. Two, lawyers. That is also a very important key factor in ADR. See, the problem with lawyers is that many of our lawyers are paid their fee for their appearance in court. Therefore, if the matter is otherwise sent for ADR like a mediation or conciliation or log adalat, they don't get their fee for appearance because it is discussed with the parties and then the matter is settled. Though there is a presence of the lawyers are also there, it's not as if they have to know for every appearance in court they are paid their fees. From my personal experience, I'm saying, I'm sure, I must tell you, I did not have very serious practice in the trial courts. I mainly practice in the high court. But in my experience, my whole life, I never ever fixed fee for any appearance in court. It was always only for the case. The case finally argued and finished, and there will be only one payment of fee for the whole case, not for the per appearance. But the system I found in North is different. It is all per appearance fee, number one. Number two, the lawyers are always interested to have the matter argued and decided. This is the mindset of the lawyers. Why do you have a very strong case? Why do you want to give up? Why do you want to compromise? Why do you want to go? That will, if you go, that will show that you have your case is weak. So don't go for such sort of efforts. This is the normal advice given by the lawyers. I had after my retirement, I do my arbitrations. I'm in Delhi. I do my arbitrations. I do my mediation. I do my consultation. I do my conciliation also. All these things I do. I had a very good case referred by court for mediation. And with the permission of the lawyers, I spoke to the parties. I had an excellent couple of sessions with the parties, and the parties almost agreed for a settlement. And for that, before that, I wanted the parties to sit together and have, to spend some time for discussing on the modalities. And I asked them to come the next day. The next day, the parties came. They reported, sorry, sir. So I asked one of the parties as to what happened. They said, sir, don't quote us. To tell you honestly, our lawyers told us that you have a very strong case. Why do you want to give up? Why do you want to concede? Why do you want to give any concession? Don't give anything. You have a strong case. I was shocked. What to do? Since lawyers are also part of my family, because I love my lawyers. The lawyers fraternity, I'm very fond of them. So I did not tell this to anybody. I'm not telling the name also. But this is the mindset of the lawyers. The mindset of the lawyers should change. They should be in a position to tell the parties that, as far as you are concerned, it is irrelevant as to how you win the case, how do you get the relief. It may be through mediation, it may be through arbitration, it may be through conciliation, it may be through log adalat. The fee that you have to pay me as a lawyer is the fee for conducting your case and getting you relief. How do you get the relief is immaterial. And this will have to pay me a reasonable fee. Fix the fee also. Instead of appearance in court, fix a reasonable fee also. So once you change your mindset, the lawyers change the mindset like that, then the people will be very happy. I tell you honestly, people are very happy because here is a lawyer who has understood my case and who is there to assist me rather than to harass me. This should be the impression that the litigant should get. He is actually assisting me not to continue with my litigation. He is assisting me to get a solution as early as possible. So he will have a lot of faith in you. And the moment you have this sort of faith, you will get more cases. This has been my experience, I'm telling you. I had experiences where I have sent out the parties. I have declined to take up the case in the sense of not to institute a case. I asked them, this is not a case for you to go to court. This is a case for you to find a solution. Otherwise, through a medium of mediation or conciliation, never ever go to the court. And they were extremely happy in such cases, because they were happy that they got the right advice. Otherwise, they would have spent their whole life in court. In South, we have a saying, if you want your family to be fully finished, you need only two things. One of the two things. One, a good civil litigation. Other, a kidney patient. If either of these you have, you are finished because, you need to continuous treatment as far as a kidney patient is concerned. And as far as litigation is concerned, you need to pump in money like anything from the civil judge junior division, it goes to senior division, then comes to the high court, then goes to the Supreme Court. It goes like that, one or two generations. In sitting in Supreme Court, I have seen 3-4 generations fighting cases, and I asked them, what have you finally obtained? They said nothing. Only the lawyers prospered. Many of the lawyers have become quite rich. I had a case where I found that an institution spent 2 crores in a year for litigation only. I will not divulge any of the names, but I'm saying, see, this is really painful. The mindset of the lawyers should also change. They should help, because they are also part of this administration of justice. It is not the duty of the court only. Court means judges only. No, the lawyers are very much part of the administration. That's why you are called officer of the court. You have a duty to the court. You have a duty to the client. You have a duty to the opposite counsel. You have a duty to the society. On all these 4 counts, you have a duty to give the best advice to the client to have the matter settled, and with the precondition that the client should pay you a reasonable fee. If this attitudinal change is there, then things will improve. The third attitudinal change required to be changed is from the side of the litigants. The litigants should know that a lawyer who helps them to get out of the court as early as possible, a lawyer who helps them to have the redressal of their disputes even without the court, he should be the best friend lawyer for him, and that lawyer should be paid more than the normal fee. If the litigants have this sort of an attitude, for such people who assist me to get my disputes resolved, I should pay more fee, then the litigants' attitudinal change will have a lot of reflection in the dispute resolution situation in India. So there needs to be a change in the attitude and the approach of the court, the lawyers, and the litigant public. So with this, probably I must stop here. If there is anything left, we can have an interactive, because you have we have a little more time only left. We have a few question session also. I will elaborate at that time. Thank you. All the best, and Jai Hind.
Thank you so much, Your Lordship. Now we'll be taking some questions from the audience. John, if you have the questions.
Yes, sir.
Lordship, meanwhile, I'd like to add just one personal question from my side. This is with respect to arbitration. We have seen several good arbitration institutions all across the world. We have Singapore Arbitration Center, Hong Kong. We have London, one in London. And in India, we have tried to incubate such arbitration institutions in the last 3-4 years. We've been a little bit late in that effort. However, we are progressing in that direction. We have one Delhi International Arbitration Center that was formerly a Delhi High Court Arbitration Center that is doing relatively well. We have one in Bombay. But we are still short of an international arbitration institution which can match the standards of the other counterparts. We have a recent amendment, we have a recent statute which is coming to overtake the existing arbitration institution, and it has been introduced as New Delhi International Arbitration Center. However, what are other things that we can do? Because as lawyers, while we are drafting agreements and everything, it is very important that we that is the first place where we designate the arbitration institution. That is the first place where we probably lay down a foundation towards the appointment of an arbitrator or an arbitration institution. So what are the steps that India can take to probably bring forward its role in the international arbitration scene, even for domestic arbitration?
Yeah, thank you, Vaibhav. You touched on 2 aspects. One is domestic arbitration, the other is international arbitration. See, be it domestic or international, you can have the sender, because this is, that's why I said, you remember the word I used is party attorney. Both parties can agree be it an international dispute or a domestic dispute, that our disputes in the event of we are not able to sit together and finish it off. Then let me without forgetting it. So when you draft your agreements, please include a clause that when there is a dispute, we will not go straight for arbitration. We will try to have the issues resolved through mediation. So incorporate a clause for a mediation. We have Delhi International Mediation Center also. There are several mediation centers: Delhi, Bangalore, Bombay, Chamber of Commerce and Staff, several places. Or you can have a neutral. Several people, several corporates have nominated me on their own, to have as a mediator. I have no problem. So you can have several such people to be. So incorporate a clause for mediation in the agreement. Number one. Number two, be it national, domestic or international, you can say that the disputes will be settled through arbitration through the international arbitration center, say Delhi, or international arbitration center Bangalore, or international arbitration center Bombay. We have 3, 4, or we have a international ICA. Here in Delhi only, we have, what is that ICA? Indian Chamber of Indian Council of Arbitration, right? Indian Council of Arbitration. You have FICCI. So there are several such platforms available. So instead of, if you go to ICA, the International Court of Arbitration for an international dispute, international arbitration, I tell you, then I'm sure you know it. You'll have to pay through your nose. It's quite expensive. Quite expensive because the procedure is different. The expense is different, the approach is different, it's very complicated. So instead of that, you can have the sender mentioned in your agreement when you draft the agreement also. And as you all know, since you have touched this arbitration, let me just take it forward. Even in arbitration, I used to try mediation also. I have several such success stories in my arbitrations. During the initial stage of arbitration, when the arbitration has proceeded, when even at the stage of arguments also, I have asked the parties that after identifying the area of dispute, I asked them whether why don't you try for a mediation. And the parties have cooperated and have settled 3 as of now, and a couple of them are in process also. So it's permission under Section 30. Once it is the duty of the tribunal to encourage settlement. This is actually the statutory expression used there under Section 30. So I have, as an arbitrator myself, mediated and finished. I have outsourced this mediation to somebody else, and that mediator has sent a report, and then in terms of that report, we have settled it. So it saves time, it saves money, it saves energy also. So I have tried this ARB also in my arbitration. So it's very important at the time of when you initiate the process of arbitration.
Thank you so much, Your Lordship. We have our first question from Shresh Pathak. He's asking, in the age of modernization, we are forgetting our age-old cultural values, which has prescribed many ways of settling dispute. What's your suggestions on adoption of ancient Indian ways of settlement of dispute?
Ancient methods.
Probably he's wishing to understand if there are certain other modes of settlement which were adopted earlier, which are beyond these 4 existing modes of ADRs.
There are several modes. I tell you, I've gone to Mangalore. Mangalore, there is a place, there's a particular place. He is the head of that institution. There's a popular belief that before him, nobody will speak the untruth. So people will come before him. Both sides will tell their versions, and he will ask them, you say what is the truth. And the truth is, he takes a decision, and the matter is finished. In that, there is nobody who will challenge it. If the one who challenges it will invite wrath of the deity. This is the popular belief there. I just forgot. It's a very popular place there in Mangalore. And there are in North also, in several villages, there are the village heads. And now from there only this concept of Grama Nyayalaya came in. In Gram Nyayalaya also, there are several areas where, the Gram Nyalaya can actually sit with the cooperation and involvement of the elected representatives of the Panchayat also, they can resolve the disputes. So the ancient mode, it is in our culture in India to have the disputes settled with the assistance of respectable members of the society. We used to call them mediators, Madhyasth, yes.
Second question is from Prakash Kumar. He is asking, what is the scope of private arbitrator vis-a-vis international arbitrator, institutional arbitrator, I'm sorry, especially in context of international trade disputes? What is the difference between the scope and probably the procedure?
You see, procedurally, you see, once you go to International Arbitration Center, International Court of Arbitration, it will be guided and governed and conducted only in accordance with the procedure of the International Court of Arbitration rules and the process thereon. Whereas if you nominate your own arbitrators and the arbitrators together nominate a presiding arbitrator called a third arbitrator, and the arbitrator tribunal is formed, and you concede that your disputes can be adjudicated in that tribunal. Well, it can be, the fees is flexible. You can, the arbiter tribunal fixes the fee with the consultation with the lawyers or with the parties. Whereas International Court of Arbitration, there's a fixed fee altogether in terms of the quantum of money involved. In private arbitrations also, sometimes we also think about the quantum, the gravity of the dispute and the amount of dispute involved. In terms of that, sometimes the arbitrators also used to fix fee. But as far as institutional arbitrators are concerned, there is a cap already fixed. Where, for example, in Delhi International Arbitration Center, Delhi International Arbitration Center, if you are a single member arbiter tribunal or a 3-member also, the cap is 30 lakhs rupees, whatever be the amount. If it is a small amount, in terms of the amount, the fees will be reduced also. And if the arbitration is finished within 6 months, there's an additional fee. And if you're a single member arbitrator, you have a 25% extra. So that's what it's called a scheduled fee. There's a fixed fee as far as the institutional arbitrations are concerned. Whereas in private arbitrations, where the arbitrators or the tribunal members pick the fee in consultation with the parties and the lawyers.
Thank you so much, sir. Thank you so much, sir. Third question, Your Lordship, is he's asking, can you please throw some light on famous case Afcon's infrastructure, in which Supreme Court tried to reframe the definition of judicial settlement and mediation? Is it binding on court to refer the matter to arbitration or conciliation, or consent of parties is necessary? Further, he wishes to ask, which ADR process is binding on the parties?
See, all ADR process, it is only with the consent of the parties. I told you, arbitration. The court cannot impose an arbitration on you. There must be a pre-existing agreement. Probably Weber knows it. That's why he referred to at the time of drafting the contract. The agreement between the parties would have envisaged a mechanism by which you settle disputes. You may it will be referred to arbitration in terms of Arbitration and Conciliation Act 1996. It will be referred to the International Arbitration Center, Delhi, Bombay or Bangalore, and it will be decided under the Act, etc. It's already there in the contracts between the parties, number one. Number two, even if it is there in the not there in the contracts also, the court will ask you, are you interested in going for arbitration? Then the court, only with the consent of the parties, the court can request you to go to arbitration. Then the court will, you can nominate the arbitrators, or court will assist you to nominate arbitrators, etc. So there is an involvement. So the court cannot impose any ADR on you without your assistance as far as arbitration is concerned. So too with mediation. Mediation only with the agreement between the parties that we should give a try for a mediation. Only if you agree. Merely because you don't agree, the court will not dismiss your case. No, you can still ask, I need to argue the case, or I need to face the trial. You can still say there's no problem at all. But only court will guide you that it is in your interest and in the parties also. You will save time, money, energy if you have a mediation. And only if you agree, you can go for a mediation also. Court cannot impose mediation on you. Whereas the Lok Adalat is concerned, for referring a matter to the Lok Adalat, the consent of the parties is not required, or is not mandatory, because it is the court which forms an opinion that this is an eminently fit case where it can be settled in the Lok Adalat. So for that, after informing the parties, the court can refer the matter to Lok Adalat. Then comes the matter, the last one is conciliation. For conciliation also, without, as the law stands now, without the consent of the parties, you cannot impose a conciliation on the parties. But for the court to be a conciliator, the court does not require your permission. Court can always take the role of a judicial conciliator.
Thank you so much, my lord. Your lordship, in question 4, he's asking for an advice for upcoming generation lawyers to choose ADR as their career, and at the same time, how would they convince litigants to seek resolution of disputes through ADR?
Yeah, in the upcoming generation and in the post-pandemic situation also, see, I do my arbitrations on the virtual platform. I do my mediation also on the virtual platform. I do my conferences in my virtual platform. You're not going to go to the court. You are only going to have a virtual platform for some more time. This will continue. Even after the post-pandemic, I am of the view, and I have a sixth sense telling me that this virtual courts will continue as an additional, not alternative, but an additional system functioning for a settlement of disputes. There also for the upcoming generation, I tell you, you must have the faith of the parties. How do you get the faith of the parties? That here is somebody giving them sound advice. Here is somebody giving them good advice in the interest of the party. That for solution of their disputes. If you are able to earn that faith, you have not only won a single client, he will be your ambassador, telling the whole world that if you have a problem, go to that lawyer. He will give you the right advice. Even if, but it's not a free charitable advice. You can pay the fees also, but you will get the right advice. Instead of going to other places and wasting your money or energy, you can go to him, will give you sound advice. But it need not necessarily be settlement through the court. It can be through an appropriate mode of, he can suggest to you a mediator. He can suggest to you a mode of conciliation. Can suggest to you a mode of arbitration also. So that is the trend now emerging. It's called the pre-litigation ADR. Pre-litigation ADR, the most important is pre-litigation ADR is mediation. Pre-litigation mediation, then the Commercial Courts Act, it is mandatory now. In several other litigations, several other statutes, I understand that the government is planning to introduce this mandatory pre-mediation settlements, pre-litigation mediation. So you have a very great role to play at that stage. Even before you lay a foundation of your case by taking your craft as a lawyer for a trial of a case, for institution of a case, and even before that stage, you get an opportunity to have the matter mediated between the parties and to help them to find a solution. Otherwise, your client knows, he'll be spending a lot of money in court, lot of time in court, and spending a lot of energy in court, and he will not get the money. I had a classic example where a party who is otherwise entitled to that's a case of arbitration. A party who would have earned an award for a handsome money. But when I asked them, is not a good case for some sort of a mediation. The parties were prepared, and probably that part in mediation, there is a successful mediation between the parties themselves, and they were able to settle it. And they got the money. Maybe even it's only half the money which he would have otherwise gotten an award. But in award, you don't get the money immediately. The award, sometimes it can be challenged. It can be then it goes for execution, etc. Look at the situation of pandemic. So before this pandemic, because of that, party was very prudent to get the advice with the cooperation of the council to go for that settlement. He got that money in hand pre-pandemic. That was a great boon to him. he was exuberantly happy, the matter could be settled. So simple advice on that also. So as far as you, the upcoming lawyers are concerned, I always tell you, don't encourage the parties to go for litigation, but engage the parties to go for a resolution of the disputes through an appropriate medium of ADR. But please ensure that you tell the parties on their face that your fee is not for arguing the case, your fee is for solving the problem.
Thank you, my lord. Fifth question, we are getting actually more than 5 questions today. So the fifth question is from Madhurima Menon. She is asking, what is the scope of international commercial arbitration in India in context of trade and commerce, especially during this period affected by COVID-19?
Yeah, Madhurima, it's a big problem now because in international arbitration, the international arbitrators are certainly according to the rules. The ICA rules. In ICA rules, the third arbitrator should be, unless the arbitrators agree, should be a party from a neutral country. So it should be somebody not from India. Where do you get them? You get them only from outside. Now, are they able to travel to India now? No. Are you able to travel to their place? No. So it just become a real tough time if you go for international arbitrations by following the strict rule. So I tell you, you should be in a position to read the signs on the wall and then follow the international court of arbitration rules, but have your tribunal constituted from out of Indian arbitrators. Your two sides can nominate an Indian arbitrator as a third arbitrator, but follow the rules and have the matters adjudicated here in India itself. That will be more expedient and that will be more advisable at this stage.
Grateful, your lordship.
And
Question 6.
less expensive also, yeah.
Question 6 is from Aman Rajoria. He's asking, can the system of mediation and conciliation be made compulsory and mandatory before moving to the courts?
Yeah, it's already there. I told you, under the Commercial Codes Act, Section 13, yes, it's mandatory that you go for a mediation before the institution of it. So there are in several statutes such sort of things are made mandatory. Even in Family Courts Act, there's a provision, there's a compulsory, it's called counseling. Though the counselors in family courts are not in a position to handle them for positive time, but there is a concept is already there.
Your lordship, this is the last question of the day. This is from Lizella Kolako. She's asking if there is a possibility of a war between the countries with regards to territorial boundaries, can that dispute be settled through arbitration without UN support?
Ideally, it is not arbitration. Ideally, it is mediation. There are several international disputes which are being settled in mediation also. But international arbitrations, as I told you, it can be done only with the agreement between the parties. Suppose the two countries agree or two parties in different countries agree that we go for arbitration, yes, it's arbitration. If they say it is mediation, it is mediation. So it is the party's choice that is most crucial. Which mode they choose. And in the situation which you mentioned, I would tell that mediation is more expedient and more advisable rather than arbitration, because arbitration needs to be a lot of procedures are also to be undergone in arbitration, whereas in mediation, as of now, for want of a statutory framework, it is still ad hoc. You can evolve your own mechanism and have the matters mediated, except for the two cardinal principles. One, the mediator should be a neutral person. Two, mediation is an absolutely confidential affair. The mediator shall not and cannot and should not divulge anything that is disclosed to him by either side. These are the two cardinal principles in a mediation. That is why when mediation fails also, the only one-line report is and mediation failed. He cannot make any comment on the merits of the matter.
Your lordship, that is the end of our questions today. I'll call upon John to deliver a vote of thanks.
Thank you, John. Yes.
Honorable Lordship, thank you for your valuable words and time. My Lordship, your word really inspired us a lot. Now, we have come to the end of our webinar, and a huge thanks to Honorable Mr. Justice Kurian Joseph, sir, for being with us. Your Lordship, we accept your blessings for the development of our organization in future. In this blessed occasion, I would like to thank Mr. Nitish Kumar Misra, convener of the Advocates League, Mr. Ashish Kumar Rai, President of the Advocates League, Mr. Shubham Kumar, Organizing Secretary, Mr. Harsh Jadon, Mr. Tushar Misra, Mr. Rahul Ranjan, Mr. Srish Pathak, Mr. Abhishek Jaswal, Mr. Sashwat Tripathi, Mr. Abhinav Gupta, Ms. Asta Tripathi, Ms. Amish Tripathi, Ms. Om Singhanai, organizing committee members, and entire team of TAL for making this event possible in such a short duration. The Advocates League, in association with Mahajan and Mahajan, going to organize certificate course on insolvency and bankruptcy laws in India on 25th and 26th July 2020. You will find the details on our website, and the same shall be provided in comment and discussion section in YouTube. The certificate of this webinar shall be provided within 1 week. At last, but not least, I would like to thank all participants who had been with us for this webinar. Thank you all, and wishing you all the very best. Thank you very much.
Thank you. God bless you all.
Thank you, Lord, sir.
Thank you so
Stay
much.
Thank you. Thank you.
stay healthy and stay blessed.
Thank you, sir.
Thank
Thank
you.
you, sir.
Thank you so much.